Good afternoon. I'm David Gans. I'm the director of the Human Rights, Civil Rights, and Citizenship Program at the Constitutional Accountability Center. This morning, the Supreme Court handed down its long-awaited decision in June Medical versus Russo. In a 5-4 ruling, the Supreme Court struck down a Louisiana law that required physicians that performed abortions to obtain admitting privileges at a hospital within 30 miles of the clinic. Justice Breyer wrote the plurality opinion. Chief Justice Roberts wrote a concurring opinion. And all of the other conservative justices wrote dissents. Alito, Thomas, Justice Kavanaugh, Justice Gorsuch, each filed dissenting opinions. Some Supreme Court opinions require the court to grapple with really difficult constitutional questions. This was not one of them. 4 years ago, in a case called Whole Women's Health versus Hellerstedt, the Supreme Court struck down a virtually identical law. In fact, as Justice Breyer noted, this was word for word identical. There was no daylight between the two. And in the lower courts, they had upheld it anyway. A very conservative decision by the Fifth Circuit said this law could go into effect. And today, 5 justices said that was wrong. The law was unconstitutional. Again, under the Constitution and the court's precedent, this was open and shut. The admitting privileges requirement in Louisiana, like the one in Texas, would shutter abortion clinics. They would prevent women from enjoying their constitutional rights, would serve no health purpose. Chief Justice Roberts had been in dissent 4 years ago in the Whole Women's Health case, but he recognized the court's duty was to follow the law. And if lower courts can brazenly ignore on-point Supreme Court decisions, it's really striking a severe blow against the rule of law. And 5 justices said no, the lower court should have followed binding Supreme Court precedent and said this law is unconstitutional because, again, it's the same law as the one the Supreme Court struck down 4 years ago. And it's notable, this is the first time Chief Justice Roberts has voted to strike down a state regulation of abortion. What has changed since Whole Women's Health, the court's composition has changed, and I think that the thinking in the lower courts was this would set up a chance for the Supreme Court to gut prior precedents, perhaps even overruling the 2016 decision. And again, by a 5-4 vote, the court said, no, we are going to follow our existing precedents. And Justice Breyer, who wrote the plurality opinion, also wrote the opinion in the Whole Women's Health case 4 years ago. And his opinion is very much like that opinion. It applies the undue burden standard, which is the governing standard in this area, to the facts. And it says this is going to shutter clinics. It's a sham. It would devastate access to abortion. It doesn't serve any purpose. It's designed to make it harder to obtain abortions. It's unconstitutional for that reasons. Roberts did not join Breyer's opinion. He filed a separate concurring opinion, and he stressed this was a law that imposed a substantial burden on access to abortion. The court, in fact, had already said it imposed a substantial burden on access to abortion. It is therefore unconstitutional, and Roberts agreed that when there's a showing that there's a substantial burden, such a law is unconstitutional. It's important to kind of focus on what the dissents did. There were 4 justices who refused to strike this law, even though the court had struck down a previous identical law that was word for word the same, and each filed dissenting opinions. This is an unusual case in that all the conservative justices filed dissenting opinion. And what these opinions show is there are 4 justices on the court that will take an extremely cramped view of any prior Supreme Court precedents that protect the right to choose abortion. They will look for any means to sort of say, oh, well, this is slightly different. And so here you had a virtually identical case that had struck down the same statute, and still they said this can go into effect. And they didn't say you should overrule these cases. They just said it's different. The facts are different here. But this would allow states to allow the court to gut the right to choose without formally saying we overrule Planned Parenthood versus Casey or we overrule Roe. But it would allow states to impose very restrictive burdens and burden abortion rights in very arbitrary ways, and essentially subject the right to abortion to a death by 1,000 cuts. And running through the dissents, these 4 dissents, is a move to really remake the law radically in a lot of different ways. One, the dissenter said we should change the laws that allow abortion clinics to bring lawsuits to vindicate the rights of their patients. This was a perfect example of a case where that makes sense, because it was a case that was regulating how the clinics operated, insisting that for arbitrary reasons they had to have admitting privileges requirement that served no health purpose and was really just designed to restrict access to abortion. But the dissenter said the clinic shouldn't be allowed to challenge that law. You should have to bring in women as patients, and this is decades of precedent. They sort of are brushing aside. One of the sort of touchstones of the Supreme Court's case law since Planned Parenthood versus Casey was that the liberty, the right of reproductive choice, had to be given real substance, and instead, the dissenters in this case would kind of leave a wooden shell. They would strip the right of reproductive choice of the strong constitution of the strong protection that the Constitution and decades of precedent makes clear. And the worrying thing is this was a 5-4 ruling. Roberts joined in striking it down, but in a situation where the court had previously said this was already unconstitutional. So this is going to be sort of an important victory. But we have 4 justices on the court that are really going to allow states to do almost anything. Any kinds of arbitrary restrictions seem to pass muster in their view. And if you want more information, to read our brief, to read the statement we put out, it's www.theusconstitution.org. And so we filed a brief in this case that goes through the Constitution's text and history and the broad protections of liberty and how the courts have vindicated that. And we're happy to see that this was a 5-4 ruling that struck down the Louisiana statute. Thanks so much.